All right. Note on Unitrin Inc. versus American General Corp. In Unitrin Inc. versus American General Corp. of 1995, the American General Corp. announced a tender offer to purchase all of the stock of Unitrin Inc. at $50.03 per share. Unitrin's board responded by taking several defensive measures, including the adoption of a poison pill and a program to repurchase up to 10 million of Unitrin's 51.8 million shares. Mark. Okay. Poison pill. Adopt a poison pill. Repurchase a lot of shares. On the open market at the same price, Unitrin's certificate of incorporation provided that a business combination with more than a 15% shareholder had to be approved by a majority of continuing directors or by a 75% shareholder vote. Unitrin's directors collectively held 23% of Unitrin's stock prior to adoption of the repurchase program. The directors did not intend to sell their stock to Unitrin under the repurchase program. American General brought an action in Delaware Chancery Court to enjoin Unitrin from completing its repurchase program. The Chancery Court issued a preliminary injunction against Unitrin at a point when Unitrin had purchased nearly 5 million shares of its stock, partly on the ground that since its shareholder directors were not selling their stock, the effect of the repurchase program would be to increase their stock ownership from 23% to over 25%, thereby giving them a veto under the 75% supermajority voting provision. The Delaware Supreme Court reversed for a decision by Chancery under the standards it set out. The Supreme Court's opinion provides an important gloss on Unical. Reading: the Court of Chancery erred in applying the proportionality review Unical requires by focusing upon whether the repurchase program was an unnecessary defensive response. The Court of Chancery should have directed its enhanced scrutiny first upon whether the repurchase program the Unitrin board implemented was draconian by being either preclusive or coercive, and second, if it was not draconian, upon whether it was within a range of reasonable responses to the threat American General's offer posed. Consequently, the interlocutory preliminary injunction of the Court of Chancery is reversed. The Court of Chancery and all parties agree that proxy contests do not generate 100% shareholder participation. The shareholder plaintiff argues that 80 to 85% may be a usual turnout. Therefore, without the repurchase program, the director shareholders' absolute voting power of 23% would already constitute actual voting power greater than 25% in a proxy contest with normal shareholder participation below 100%. The Unitrin's board did not have unlimited discretion to defeat the threat it perceived from the American General offer by any draconian means available. See Unical. Pursuant to the Unical proportionality test, the nature of the threat associated with the particular hostile offer sets the parameters for the range of permissible defensive tactics. Accordingly, the purpose of enhanced judicial scrutiny is to determine whether the board acted reasonably in relation to the threat which a particular bid allegedly poses to stockholder interests. Next page. That's from Mills Acquisition Co. versus Macmillan Inc. of 1989. So, courts, courts, commentators, and litigators have attempted to catalog the threats posed by hostile tender offers. Commentators have categorized three types of threats: opportunity loss, being one of them. Structural coercion and substantive coercion. An opportunity loss where a hostile offer might deprive target shareholders of the opportunity to select a superior alternative offered by target management, or we should add offered by another bidder. Structural coercion, part 2, is the risk that disparate treatment of non-tendering shareholders might distort the shareholders' tender decisions. And third, substantive coercion, the risk that shareholders will mistakenly accept an underpriced offer because they disbelieve management's representations of intrinsic value. The record reflects that Unitron's board perceived the threat from American General's offer to be a form of substantive coercion. The record appears to support Unitron's argument that the board's justification for adopting the repurchase program was its was its reasonably perceived risk and substantive. They believed it to be substantive coercion that shareholders might accept the offer because of ignorance or mistaken belief regarding the board's assessment of the long-term value of Unitron stock. See Shamrock Holdings Inc. versus Polaroid Corp. The adoption of the repurchase program also appears to be consistent with the court's holding that economic inadequacy is not the only threat presented by an all-cash for all shares hostile bid, because the threat of such a hostile bid could be exacerbated by shareholder ignorance or mistaken beliefs. And that comes from Paramount Communications versus Time Inc. And an examination of the cases applying Unocal reveals a direct correlation between findings of proportionality or disproportionality and the judicial determination of whether a defensive response was draconian because it was either coercive or preclusive in character. As common law applications of Unocal's proportionality standard have evolved. Good Lord. This is a hard standard to grasp. That's the inquiry of this standard. At least 2 characteristics of draconian defensive measures taken by a board of directors in responding to a threat have been brought into focus through enhanced judicial scrutiny. In the modern takeover lexicon, it is now clear that since Unocal, this court has consistently recognized that defensive measures which are either preclusive or coercive are included within the common law definition of draconian. Okay, draconian includes preclusive and coercive defensive measures. If a defensive measure is not draconian, however, because it is not either coercive or preclusive, the Unocal proportionality test requires the focus of enhanced judicial scrutiny to shift to the to the what? Range of reasonableness? Shift to the range of reasonableness, which comes from Paramount. I'm going to be briefing that case later. It doesn't even say that this range of reasonableness is even a standard. Actually, this is Paramount Communications versus QVC. So proper and proportionate defensive responses are intended and permitted to thwart perceived threats. When a corporation is not for sale, the board of directors is the defender of the metaphorical medieval corporate bastion and the protector of the corporation's shareholders. The fact that a defensive action must be coercive or preclusive does not prevent a board from responding defensively before a bidder is at the corporate bastion's gate. The Court of Chancery found that the Unitron board reasonably believed that American General's offer was inadequate. Upon remand, in applying the correct legal standard to the factual circumstances of this case, the Court of Chancery may conclude that the implementation of the limited repurchase program was also within a range of reasonable additional defensive responses available to the Unitron board. In considering whether the repurchase program was within a range of reasonableness, so this is reasonableness factors. So this is a new standard of proof number, 4. Let's call this 3 right here, draconian. Or I don't even know. There's proportionality standard, which I think tries to capture what happened in Unocal. Draconian is kind of a new name, but it also sort of those are kind of also talking about the standards 1 and 2 that we talked about in Unocal, but they're probably renamed because they're a little bit different. Now we got this new standard of proof, 3 or 4. The range of reasonableness. The factors include whether it is statutorily authorized form of business decision, which a board of directors may routinely make in a non-takeover context, and 2, as a defensive response to American General's offer, it was limited and corresponded in degree or magnitude to the degree or magnitude of the threat. So these are all the same standards, i.e. assuming the threat was relatively mild and the response relatively mild. And 3rd, with the repurchase program, the Unitrans board properly recognized that all shareholders are not alike and provided immediate liquidity to those shareholders who wanted it. The Inree Gaylord Container Corp shareholder litigation of 2000 observed a defensive measure is preclusive when its operation precludes an acquisition of the company. A defensive measure is coercive when it operates the force management's preferred alternative upon shareholders. Appreciate those definitions because we absolutely need the definitions of those since they both are making up what is called draconian. So we get to move through past the note on Unocal because I read that in the Unocal recording, and we get to go to next section. Well, first there's law here, which we already cited. ALI, Principles of Corporate Governance 6.2, somewhat replaces there was the all holders rule, which did replace Delaware's approach, and ALI probably derived therefrom and probably applies, but only where it's been accepted to apply by the states that follow it, I suppose. So that's a citation that's relevant for that reason. The next section of this chapter on corporate combinations, tender offers, and defending control, obviously we're in defending control section, is poison pills. And I'm going to read this section. It looks like it contains some note cases. Probably will not get into the next case. It'll be a bit too long, but we will go to Red One afterwards, which is an important case in this body of law. So, poison pills. A poison pill, also known as a rights plan or a shareholder, rights plan. Is a plan under which the board of directors of a corporation creates rights that are distributed or distributable to shareholders. Under the rights, upon the occurrence of certain events, shareholders other than a tender offer bidder or prospective bidder have the right to purchase stock in the corporation or under certain circumstances in the acquirer at a deep discount, normally half price, because the potential exercise of the rights would dramatically dilute the value of the target stock that the bidder proposes to acquire. The mere potential that the rights will be exercised may serve as a deterrent to making a bid in the first place, although for reasons that will be explored in the materials that follow, a pill is usually not a complete showstopper. The actual mechanics of pills are highly complex and have evolved over time. Here's a description of fairly standard modern version of the pill taken from Carmody versus Toll Brothers of 1998. The corporation whose pill is described was named Toll Brothers. The rights plan would operate as follows. There would be a dividend distribution of one preferred stock purchase right, a right for each outstanding share of common stock as of July 11, 1997. Initially, the rights would attach to the company's outstanding common shares, and each right would initially entitle the holder to purchase 1,000th of a share of a newly registered title Junior A preferred stock for $100. The rights would become exercisable and would trade separately from the common shares after the distribution date, which is defined as the earlier of 10 business days following a public announcement that the acquirer had acquired or obtained the right to acquire beneficial ownership of 15% or more of the company's outstanding common shares. The stockholder acquisition date, or B, 10 business days after the commencement of a tender offer or exchange offer that would result in a person or group beneficially owning 15% or more of the company's outstanding common shares. Once exercisable, the rights remain exercisable until the final expiration date, June 12, 2007, 10 years after the adoption of the plan, unless the rights are redeemed by the company. The dilution, the dilutive mechanism of the right is triggered by certain defined events. One such event is the acquisition of a 15% or more of Toll Brothers stock by any person or group of affiliated associated persons. Should that occur, each rights holder, except the acquirer and its affiliates and associates, becomes entitled to buy 2 shares of Toll Brother common stock or other securities at half price. That is, the value of the stock received when the right is exercised is equal to 2 times the exercise price of the right. In that matter, this so-called flip-in feature of the rights plan would massively dilute the value of the holdings of the unwanted acquirer. The flip-in feature of a rights plan is triggered when the acquirer crosses the specified ownership thresholds, regardless of the acquirer's intentions with respect to the use of the shares. At that point, rights vest in all shareholders other than the acquirer, and as a right, those shareholders become entitled to acquire additional shares of voting stock at a substantially discounted price, usually 50% of the market price. Commonly, rights plans also contain a flip-over feature entitling target company shareholders, again, other than the acquirer, to purchase shares of the acquiring company at a reduced price. That feature is activated when, after a flip-in triggering event, the acquirer initiates a triggering event such as a merger, self-dealing transaction, or sale of assets. The rights in the case at bar have a standard flip-over feature, which is triggered if after the stock acquisition date, the company is made a party to the merger in which Toll Brothers is not the surviving corporation, or in which it is a surviving corporation and the common stock is changed or exchanged. In either event, each rights holder becomes entitled to purchase common stock of the acquiring company, again at half price, thereby impairing the acquirer's capital structure and drastically diluting the interest of the acquirer's other stockholders. A flip-over pill is normally triggered by and that's the end of the cite from the Toll Brothers case. So a flip-over pill now is normally triggered only by a corporate combination between the bidder and the target following the initial tender offer. The effect of a flip-over pill may therefore be moderated where the bidder's business plan allows it to forgo such a merger. A flip-in pill is much more wide-ranging in its applicability, but usually the rights issued under such a pill can be redeemed by the target's board for a nominal consideration at any time before a triggering event and often for a brief period thereafter. Among public companies, poison pills are ubiquitous. Should the validity of the pill turn on whether the company's board adopted a pill before there was a contest for control, and you see Independence Fed Savings Bank versus Bender, 2004, refusing to compel pills redemption because it was adopted during a merger contest. Bircham versus Unison Bancorp denied summary judgment on question whether, in this 2003, whether adoption of a poison pill in the heat of a takeover was itself a breach of directors' fiduciary duty. And by denying summary relief, they probably ruled in favor of the company standing up the poison pill during a fight. A case of national importance, Moron versus Household International Inc., held that of 1985 held that a corporation's board of directors could validly adopt a poison pill and do so unilaterally, for example, without approval of the stockholders. In issuing the shareholders' rights, the household's board invoked the authority it enjoyed under the so-called blank stock authorization, by which Delaware, in Section 157 of the Delaware General Corporation Law, and most states permit the Articles of Incorporation to contain a provision that empowers the board to issue shares, rights, and other options, privileges, and preferences as the board may from time to time establish. So we don't even need shareholder vote not required, basically. To the complaint that the rights plan usurped the shareholders' rights to receive tender offers by changing household's fundamental structure, the court observed the rights plan is not absolute. When the household board of directors is faced with a tender offer and a request to redeem the rights, they will not be able to arbitrarily reject the offer. They will be held to the same fiduciary standards any other board of directors would be held to in deciding to adopt a defensive mechanism. The same standard as they were held to in originally approving the rights plans, Unical at a bunch of page numbers. There is a little change in the governance structure as a result of the adoption of the rights plan. The board does not now have unfettered discretion in refusing to redeem the rights. The board has no more discretion in refusing to redeem the rights than it does in enacting any defensive mechanism. Moron emphasized the redemption provision of the pill, seeing this as crucial to the pill's validity. What are the benefits of kicking the pill's validity down the road to when there is a contest and the bidder or target shareholder challenge the board's decision not to redeem the pill? Is there a downside of testing the pill's validity in the heat of a takeover contest? In the few early decisions, the court reviewing the non-redemptive decision were disposed to order the target board to redeem the pill. See South Down Inc. versus Moore McCormick Resources in Texas, 1988, concluding that entrenchment, not the stockholders' interest, motivated board's decision not to redeem the pill. A Copeland Enterprises Inc. versus Goost in Texas, 1989, upholding the validity of the pill at the moment the hostile bid was commenced, but expressing an intent to order the pill's redemption when the bidder's tender offer closed if the bill was still outstanding. As the pill became more prevalent, judicial decisions have been more deferential to the target's board. Reciting Dynamics Corp. of Amer versus WHX, Connecticut, 1997, Moore Corp. versus Wallace, Delaware, 1995, refusing to order redemption where board alleged the hostile bid undervalued the firm, even though 70% of the shareholders had tendered their shares in response to the bid. While legal skirmishes continued on a variety of issues posed by the pill, the courtroom is not the only antidote the frustrated bidder can seek. There is an avenue of the proxy fight, electing a new majority beholding to the bidder, who can be expected to not just redeem the pill, but do the deal. Can setting a very low ownership percentage at which a flip-in or flip-over rights are triggered violate Unical Unitron standards? Question mark. And then in italics, Versata Enterprises Inc. versus Selectica, Delaware, 2010, holds that setting the pill level at 4.99% did not render the pill beyond the range of reasonableness. Pills provide important protection against unwanted suitors, and lawyers have been very innovative in their quest to make their clients' pill bulletproof. The dead hand provision of the poison pill is one such innovation. It provides that the rights plan cannot be redeemed except by the incumbent directors who adopted the plan or their designated successors. The dead hand provision seeks to reduce one obvious route for an unwanted suitor to ultimately overcome the pill, undertaking a successful proxy contest so its nominees make up the new majority of the target board and thus can redeem the pill and do the deal. In Carmody versus Toll Brothers, Inc., Delaware, 1998, Vice Chancellor Jacobs declared the dead hand pill invalid under Delaware law on several grounds. So then why? What? First, the dead hand pill violates the Delaware statute by impermissibly creating voting power distinctions among directors without authorizing in the articles of incorporation and by interfering with the director's statutory power to manage a business and affairs of the corporation. Second, a dead hand pill is unlawful under Blasius, see Chapter 4, because it purportedly interferes with the shareholders' voting franchise without compelling justification. Third, the dead hand pill is a disproportionate defensive measure under Unical Unitran because it either precludes or materially abridges the shareholders' rights to receive tender offers and to wage a proxy contest to replace the board. In contrast to Carmody, a dead hand pill was upheld by a decision that relied heavily on the language of the pill validation statute of the corporation's domicile, Georgia, Invacare Corp. Versus Healthdyne Technologies in 1997. Somewhat of the sequel to the dead hand bill is the delayed redemption provision, which provides that if a majority of the directors are replaced by a stockholder action, the newly elected board cannot redeem the rights for 6 months if the purpose or effect of the redemption is to facilitate a transaction with an interested person. Quick Turn Design Systems versus Shapiro. So that's a new strategy. That's the delayed redemption provision. This is another one. And that was the definition. All right. The holding in the case I just cited, delayed redemption provision is invalid under Delaware law. Also invalid, but good to know. There's a lot written here about why it's invalid. One of the most basic tenets of Delaware corporate law is that the board of directors has the ultimate responsibility for managing the business and affairs of the corporation. Section 141A requires that any limitation of the board's authority be set out in the certificate of incorporation. The quick turn certificate of incorporation contains no provision purporting to limit the authority of the board in any way. The delayed redemption provision, however, would prevent a newly elected board from completely discharging its fundamental management duties in the corporation and its stockholders for 6 months. While the delayed redemption provision limits the board of directors' authority in only one respect, the suspension of the rights plan, it nonetheless restricts the board's power in the area of fundamental importance to the shareholders negotiating a possible sale of the corporation. Therefore, we hold that the delayed redemption provision is invalid under the Section 141, which confers any newly elected board of directors full power to manage and direct the business and affairs of a Delaware corporation. The delayed redemption provision prevents a newly elected board of directors from completely discharging its fiduciary duties to protect full interests of Quick Turn and its stockholders. The delayed redemption provision tends to limit in a substantial way the freedom of newly elected directors' decisions on matters of management policy. Therefore, it violates the duty of each newly elected director to exercise his own best judgment on matters coming before the board. The conclusion is the delayed redemption provision would prevent a new quick turn board of directors from managing the corporation by redeeming the rights plan to facilitate a transaction that would serve the stockholders' best interests, even under circumstances where the board would be required to do so because of its fiduciary duty to the quick turn stockholders. Because the delayed redemption provision impermissibly circumscribes the board's statutory power under Section 141A and the director's ability to fulfill their concomitant fiduciary duties, we hold that a delayed redemption provision is invalid. On that alternative basis, the judgment of the court transfer is affirmed. Contra, AMP Inc. versus Allied Signal in Pennsylvania 1998 relied on both the state's poison pill validation and the constituency statutes and The court reasoned that the delayed redemption feature of a poison pill was valid. Thank you, Pennsylvania. Being consistent with the state's public policy, and because it interfered with the board's discretion for only for a finite period of time. So, in the last few proxy seasons, shareholders have frequently proposed declassifying board of directors. Recall that corporations can provide the directors can serve staggered 3-year boards, so only that 1/3 of the board turns over each year. In reflecting on why activist shareholders are eager that their portfolio companies elect all their directors annually, consider the following. During a 5-year study period, these professors found that staggering boards increased the likelihood of companies remaining independent from 34% to 61%, and the staggered boards reduced the likelihood of the first bidder being successful from 34% to 14%. And another article asked the question, why should a staggered board make the pill more effective? Hint, consider the protection from removal that directors serving on a classified board enjoy in Delaware. And that takes you to the next case, Air Products and Chemicals, Inc. versus Airgas. And we're going to just start reading that in another session.